And now I'd like to introduce today's speakers. Eric Ledbetter is a partner and immigration attorney specializing in complex business immigration matters for U.S. and global companies. He represents investors, doctors, researchers, business executives, and high-tech workers. He has broad experience with multiple types of visas and non-immigrant visa status, as well as J-1 waivers. Mr. Ledbetter also advises companies on a range of workplace issues, including immigration and I-9 compliance, EVerify best practices, and avoidance of discrimination claims based on alienage and citizenship status. Meredith Dahl practices in the area of immigration and nationality law, focusing primarily on business immigration matters, including non-immigrant classification petitions for professionals, treaty workers, intra-company transferees, and their families. She assists employers with immigration policy and strategy planning, including risk management, layoffs, and M&A impact planning. She has advised clients on immigration-related compliance matters, including I-9 audits, EVerify enrollment, and workforce verification. Nneka Ume focuses her practice on immigration. She has extensive experience advising large and small corporations on non-immigrant petitions, family and employment-based permanent resident processes, and I-9 compliance for foreign nationals. She has broad experience with B, E, H, L, O, and TN non-immigrant visas. And now I turn it over to today's speakers.
Thank you, Kim, for that introduction, and thank you, everybody, for attending today. We have people in our various offices. We also have a good number of people who are attending via webinar. If you do have any questions at any time during the presentation, feel free, if you're in one of the offices, to ask your question, and or you can save it until the end. We'll have a formal Q&A session at the end. If you're on the webinar, you can type your question in at any point, and we'll try to work it in or take it at the end. And then also, I know a number of you have submitted questions prior to today's presentation, and so we've reviewed all those questions, and we'll try our best to work them into the materials. But if we don't get to your exact question, feel free to ask it during the Q&A. So each of us on the panel is an immigration attorney, and today we're going to talk about I-9 and EVerify compliance. The I-9 form is administered and published by the Immigration Service, and it's enforced by the Immigration Customs Enforcement Agency, ICE. And so as we talk about I-9s and EVerifys, we will also work in the tricky issues that come up for a lot of companies that have people who are not U.S. citizens or permanent residents, but they're here in the United States and some other bases. And often that creates the trickiest, thorniest problems for us. But we'll also just talk about general basic I-9 and EVerify compliance. And as we talk about I-9 compliance, we will be sure to talk about both halves, both the ICE half and also the Department of Justice half, and I'll talk more about that in a minute. And so to sort of give you a roadmap of how we'll do this today, I'll just say a few words to set up why we care about I-9 compliance, and then Nneka Ume will talk about the top 10 challenges and issues that companies see with I-9 compliance. We all three do a lot of compliance auditing for companies, and when you do a few thousand I-9s, you start to see certain patterns and trends. And so from those patterns and trends, Nneka has worked up kind of a top 10 do's and don'ts. And then after that, Meredith Dahl will talk about EVerify compliance. What exactly is it? Who has to use it? Who can use it voluntarily? And if you are using it, how to use it in a way that's compliant with the rules. And then after that, we'll come back to me, and I will talk about investigations, both from ICE and from the Department of Justice. So our first slide, why do we care about I-9 compliance? Well, there's a federal law created by Congress in 1986 called the Immigration Reform and Control Act. At the time, there was a problem with illegal or undocumented immigration, whichever you prefer. And the thinking was that people come to the United States without documentation in order to find a job. And so it's really jobs that's driving illegal immigration. And so Congress thought, well, let's have companies be responsible at the point of hire for verifying the identity and the work authorization of their new hire, and that should shut off the magnet for the illegal employment of people without work authorization. So that was 1986. Didn't pan out quite the way they thought it might, but we still have the I-9 obligation. And we also care because if we're out of compliance, you can pick up serious fines, and we'll talk a lot about the fine structures today. If you're really out of compliance, there's also a risk of criminal penalties, but that would have to be a company that knows, you know, like for instance, there were some companies that got in trouble a few years ago because they were sending vans down to the border to pick people up and bring them up knowing they were unauthorized. I'm going to hope that we don't have anything like that happening today, so we'll mostly focus on the civil fines. We'll also talk about the conundrum that every employer has. You have to comply with your I-9 rules, but you have to do it in a way without discriminating against employees or candidates. And so we'll talk about that. And then this slide is just a slide to sort of list out the resources that are available to you. Again, USCIS publishes the I-9 form. So if you're ever not sure about the most recent version that you should be using, you can go to uscis.gov, and under the Forms tab, you'll find the I-9 form. And also the M274 is the government's handbook for I-9s, and it's a pretty helpful handbook. So if you haven't ever looked at it, you might want to consider getting that from the USCIS website as well. And then finally, if you're filling out an I-9 and you're ever just not sure, don't just guess at it. Feel free to give one of us a call. It usually takes about 2 to 3 minutes, and we can take a quick look at it, answer the question, and give you that peace of mind that when you put it away, you're not putting away a potential fine that's going to come back to haunt you someday. And so with that, I'll turn it over to Nneka.
Thanks, Eric. And thank you everyone for coming today. Our immigration team is comprised of legal project assistants, paralegals, and attorneys, and we all handle I-9 audits for our clients. And with that audit experience, we do have a list of the top 10 I-9 issues and some easy solutions for those. The first one that we'll talk about is whether or not to require your I-9 or your employees to complete Form I-9. The answer is yes. As Eric stated, all employees from November of 1986 are required to complete Form I-9. That does not include independent contractors who are not employees, but it does include seasonal employees, temporary employees, part-time, full-time, tall, short. All employees are required to complete Form I-9. The next issue that we will look at is when to complete the Form I-9 for an employee. And by the way, EE refers to employee and ER refers to employer on our slide. So the employee is required to complete Section 1 of the I-9 by their first day of employment. What we see frequently is maybe you as the employer give your employees an introductory packet on the first day, and then somewhere tucked in there is an I-9 that you ask the employee to return to you at the end of the day. Well, the likelihood is that the employee is overwhelmed and they just take all of those documents home with them, so they're not giving you the I-9 on that first day as required. So what we recommend is that as soon as that employee accepts the offer of employment, go ahead and send them that I-9 so that when they come to work on that first day of employment, they go ahead and bring that I-9 completed on their part, which would be Section 1 of that I-9. The next issue that we see is whether or not to accept copies of the employment authorization documents or whether or not receipts are acceptable as I-9 documents. The whole purpose of this I-9 program, again, is for the employer to verify the employment authorization of the employee. So most instances, those receipts are evidence of the employee applying for employment authorization, but they don't evidence that the government has authorized that individual for employment. So in general, you do not want to accept receipt notices. As with all rules, there are exceptions. So one instance is, let's say you hire STEM workers, and specifically I'm referring to STEM students who are individuals who have a degree in science, technology, engineering, or math, and they've obtained a U.S. degree so that they are entitled to 2 years of work authorization in the U.S. as long as they work for an EVerify employer. What you want to do there is you can accept the receipt notice, oddly enough, but that's because before that 2 years of employment authorization, they've already been approved for 1 year of employment authorization just by having a U.S. Degree. So again, usually it's a good idea to just ask someone if you're not sure whether or not to accept a receipt, because in most instances, a receipt is insufficient evidence of employment authorization. The next thing that we have here is an employer telling the employee which documents to show. Again, when the employee completes Section 1 of that I-9, they will document which category they fall into, whether that be a U.S. citizen, a permanent resident, or an alien with authorization to work. Let's say you see someone who's a U.S. citizen, so you say, just give me your Social Security and your driver's license. You can't do that. What you can say is you can either give me a List A document or a List B and List C document. What we see frequently is that your employee just wants to give you everything. They're just sharers, and they want you to know everything about them. So they give you their wallet and say, just pick something, and then you fill out Section 2. Well, you want to hand them that whole wallet back and say, you can either give me a List A document or a List B and List C document. Because that's the extent of advice you can give an employee regarding which documents to provide for the I-9. And I just want to reiterate, copies are not acceptable for I-9 employment verification documents. Again, you want to see the physical document in person because the government is asking you to verify that that individual has employment authorization. And you can't verify that if you're looking at a copy because you're not sure that that individual has the actual document. And next, you'll see a list of the I-9 documents that are acceptable. I won't go through all of those, but List A overall shows you that that individual has that individual's identity and that that individual has employment authorization. List B documents show you that that individual confirm that individual's identity, and then List C documents confirm that individual's employment authorization. So again, that's why you can either submit a List A document or a List B and C document. The next issue that we have is whether or not to keep copies of the verification document. And when I saw this slide, my immediate thought went to a 90s band called O-Town, and they have a song called Nothing at All, but I won't talk about that. I will instead refer you to Frank Sinatra's All or Nothing, because I think that'll give me a little more credibility. So your issue here is that you either keep all documents or you don't keep any documents. You can't pick and choose whose documents you retain, because then you run the risk of being accused of nationality discrimination. So there, what we would recommend is go ahead and retain copies of all of the employment authorization documents, and that'll help you on the back end. If you conduct an audit, then you'll have those documents handy so that you can refer back to them and look at what you looked at initially when you were completing Section 2 of the I-9. And just a question that we had here that I wanted to address, and that's whether or not you can fill out I-9 forms electronically or whether or not they have to be completed manually. And either option is okay for the employee. You just want to make sure that if that employee completes the I-9 electronically, that you either are having them sign it in person or that they're going through a signature step through that electronic system that meets the requirements of the government.
The other thing to watch out for there is if you hire an I-9 vendor to provide the electronic software, but they give you software that's deficient in some way, then you'll get a fine for every I-9 you fill out after that. This was the Abercrombie & Fitch case, where they developed their own I-9 software in-house, did it as a software problem, not as a legal compliance problem. And the software was very nice from everything I hear, except that it was deficient. It didn't have a couple of the things that an actual I-9 form would have. And so when they got their I-9 audit, they picked up a $1.2 million fine, even though ICE didn't find a single instance of an undocumented worker on their staff. They still got a $1.2 million fine.
And I don't have $1.2 million to just give to the government for a deficient I-9. So this is why we are going through this I-9 presentation today. The next option, or the next issue that we see, is filtering out old I-9s too early or too late. Let's say you have an employee that was terminated and you are just ready to get rid of that file. You're done with the employee, glad they're gone. Just keep in mind that there are I-9 retention requirements. You have to have an I-9 on file for all of your current employees unless they were hired before November of 1986. And then when you do terminate that employee, you still have to retain that I-9 for either 1 year after their termination or 3 years after their hire. Here, we recommend that you do not keep your I-9s with the rest of the personnel file, because then it's really easy to accidentally, just chuck the whole thing, and then you don't have that I-9 to show that you properly completed it when they were initially hired. Instead, you want to separate those I-9s, and in addition to that, you want to pull out those terminated I-9s and keep those separate as well, so that you can run through those either monthly or quarterly and then get rid of those I-9s as they meet the retention requirements. And keep in mind, as you get rid of those I-9s, you're also getting rid of that potential liability if those I-9s were completed incorrectly. The next thing that we want to talk about is failing to re-verify individuals that have expiring immigration documents. And what I want to note here is that you are only re-verifying individuals who check under Section 1, that they are an alien authorized to work until a period of time. So if it's a U.S. citizen or a U.S. permanent resident, you don't re-verify those individuals. So here, what we usually see is, let's say you have an employee and you renew their work authorized visa. We'll just say they're on an H-1B. So they have employment authorization because you went through the hassle of getting their H-1B renewed. Well, you still have to go through the process of completing Section 3 of that I-9 and documenting to the government that you took that step of renewing their employment, because that's all that the government will look at when they conduct an I-9 audit, is that I-9 form, and then any employment authorization documents that you have made a copy of. The next thing that we'll talk about, I'll show you the Section 3. And so what I'm referring to here is only Part C. You do not have to complete Parts A and B. Those each have their specific instances where they are used. So here you'll see in Part C, it looks very similar to Section 2 in that you complete the document title, the document number, and the expiration date, if any. So again, here, let's say you have an individual on a visa, and then you guys sponsor that individual for a green card, and they receive that green card, and they have work authorization because you were there to give them their green card and everyone's happy. Well, you still want to remember to go back and complete Section C so that you've documented on the I-9 that they have work authorization, and now that they have a green card, you no longer have to verify that individual's employment again. The next issue that we'll talk about is an employer re-verifying I-9s when it's not necessary. So don't do any more work than you have to. Don't get really excited about I-9s like I am and then decide to just re-verify everyone. Not necessary. Again, you're only re-verifying those individuals that check that last box on Section 1, which is an alien who is authorized to work until a specific period of time. This is another reason why it's a good idea to retain the documents that they show you for employment authorization, because if you're ever unsure, you should have documents in there that will point you to when their employment authorization expires. And what we recommend here as far as re-verification is letting an employee know at least 90 days before their employment authorization expires. That way, if they have to file anything with the government, that they have time to make that, to file that, and then hopefully get a resolution of that filing. Although right now, it takes a little bit longer than 90 days to get a response from the government, in my experience at least. And then here we kind of have a general listing of the typical mistakes on Form I-9. What's important to point out here is that sometimes there are technical violations that you can correct and then you won't incur any fine. And sometimes there are substantive violations and you may incur a fine, but the government will look very kindly on people who take the time to audit their I-9s and correct those errors. There's actually, I think it's called goodwill, but Eric will talk about that later. That's one of the factors that can mitigate the amount of fines that the government assesses if they conduct an audit or investigation of your I-9s. just a little bit more detail about what a technical violation looks like. We're typically talking about failing to date a form, or maybe you swap where you put the document type in section 2 so that you have it listed in the wrong column. That would be a technical violation. A substantive violation is not completing an I-9 at all for an employee, or maybe section 1 is left completely blank. So you want to be aware of those, and you can always go back and correct an I-9, but you want to make sure that you sign where you corrected that I-9 or initial, and then date that with the current date. You are not allowed to backdate I-9, so just keep that in mind if you decide to conduct an internal audit. And again, just so we all remember that you can only request a list A document or list B or C. I just want to make sure to hammer that home so that we don't have anyone who decides to advise an employee a little more precisely on what documents they provide. And then finally, we'll talk about an employer asking to see a social security card, even if the employee does not present a social security card as a list B document. Usually where we see this is we're going through an I-9 audit, and we'll see that maybe the employee provided their passport, which is a list A document, so no other documentation will be needed, but then there will also be a copy of a social security card. And as you continue to go through the I-9s, you see that there's always a copy of the social security card. That is not required for the I-9. In the event that you use EVerify, which Meredith will talk about later, the employee needs to list their social security card, but you do not have to retain a copy of the social security card. Here's another instance where it makes sense, again, to separate your I-9s from the rest of the personnel file, because usually we see this when employers just have a personnel file altogether, so all of the documents that you retain as part of that individual's personnel file end up with the I-9. But when ICE or the Department of Justice conducts an audit or investigation for those I-9s, are you going to have the time to go through and parse all of the documents and make sure that you're only giving them the I-9 documents as opposed to the documents that are in their personnel file? So again, the recommendation here is just keep your I-9 separate and only make copies of the documents that you document in section 2 of the I-9, which is what the employer completes. And now I'll show you just one last thing here, and that's this social security card. So this social security card should be a red flag for anyone. If you're completing an I-9 and an individual gives you this social security card that says valid for work only with DHS authorization, they have to give you more documents. This is not a social security card that a U.S. permanent resident or a citizen would receive. This is telling you that that individual has obtained employment authorization from the government in the form of a visa, or generally in the form of a visa. So if you see this social security card, push it back and ask for more if that's the only thing that you've received from the employee. And then Meredith will take over with EVerify.
Yay! All right, guys, I'm going to talk to you about EVerify. Before I get started, maybe think to yourself whether you're even aware of whether your company is enrolled in EVerify, if you've ever heard of EVerify. It is a web-based system developed by the government to provide some additional security for employers who are engaging in the employment verification process. So it's an adjunct to the I-9. It doesn't replace it. You still have to do the Form I-9, which, with 30 years of practice, hopefully you're getting that pretty good. Now, what the EVerify system does is it enables employers to take the data from the I-9 and enter it into an online system that electronically verifies it against DHS and Social Security Administration databases. And what that does is it allows the government to kind of check, make sure all the data matches in real time, and then give you a confirmation that that employee is authorized to work. It's totally voluntary at the federal level with some exceptions. But what I mean by that is just that the federal government has offered this as a service, but they don't mandate that you use it. Some states, however, have made the program mandatory. So we'll talk about that. At the federal level, only one type of employer is required to enroll in EVerify, and that is a federal contractor. And it's not every federal contractor, though it's basically most federal contractors, and also subcontractors who are assigned to a federal project. These contractors have to enroll in EVerify. So if you're engaged in any sort of federal contracting, it's a good idea to check your obligations, because you probably need to be enrolled in EVerify if you aren't already. The other trick to being a federal contractor is that in addition to being enrolled in EVerify, which you have to do within 30 days of your contract award, you have to verify some existing employees, which is in any other context a completely bad thing to do, and we never want you to do it. But when you're a federal contractor, you have to make an election in EVerify and confirm what existing employees you are going to verify. And that can be limited to just your existing employees who are going to perform work on the contract, or you can actually elect to verify your entire existing workforce if you are up to that challenge. Aside from strategic decisions, that you'll have to consider closely internally, there's a difference in time frame. If you elect only to verify existing employees who are working on the contract, then you have 90 days to do that. If you're going to do your whole workforce, you have 180 days from the election to do that. So what's different then from the federal obligation is the state obligation. Some states really love EVerify, and they've made laws requiring employers who are operating within their borders to enroll in EVerify. Usually there's a size limit associated with that, so it's employers with maybe more than 3 or more than 10 employees. Some states restrict it to certain types of employers, so like state contractors, so mimicking the federal rule. And then other states have taken it in a different direction and actually restricted some of the activities employers can engage in if they enroll in EVerify. So not restricting actual enrollment in EVerify or use of the system, but maybe placing restrictions on how employee data is shared, especially data related to work authorization and immigration status. When we are thinking about enrolling, so if it's voluntary or even if it's not, some good things to think about before you enroll. I always like to start with what it means to enroll. When you enroll in EVerify, you're not just creating a profile and signing up for Facebook. You're signing a memorandum of understanding with ICE, and so it's an enforceable contract. And what you're agreeing to do is provide the government with data, the data that you would normally just gather and store in your I-9. So you're affirmatively providing it to the government in electronic format. And, on their side, the government is monitoring that data and they look for certain data patterns. And if your data shows these certain patterns, you can be reviewed, you can be audited, have an auditor actually come out and asked to be taken through your EVerify process, and you can be referred. You can be referred to HSI, Homeland Security Investigations. That's the investigatory arm of ICE that does I-9 audits. You can be referred to IER, which is the agency within the DOJ that investigates immigration-based discrimination. So it's a lot of significance within that choice that I think should be considered. You should also think about things like how you're going to enroll. Like, we want you to be compliant, so thinking about which sites you're going to enroll, which sites you're going to actually engage in EVerify, who is going to be doing this for you, how are you going to train them. These are all good things to think about before you enroll, because they will promote compliance after you enroll. And not to sound like too much of a Debbie Downer, I do have some advantages of enrolling. I'm actually a big proponent of EVerify. First, if you use it, you create a rebuttable presumption of work authorization anytime you get a work authorized result. And this is very useful in an audit context. If an individual is later discovered to not have employment authorization, you have a rebuttable presumption that you didn't know. So it creates this safe harbor and protects you in certain circumstances from fine enhancements and, knowing employment of unauthorized worker fines, which are pretty hefty. The other advantage is your STEM OPT employment. So like NECA mentioned earlier, there's a certain class of foreign nationals who, after getting a U.S. degree, have entitlement to work authorization. And these STEM degree holders are able to engage in 24 months of additional employment authorization, which is super, super useful in a lot of contexts, but only if they're working for an EVerify employer. And I will say that STEM F1 students with STEM eligibility know this. They check whether employers are enrolled in EVerify, and it informs their decisions. So if you're in a very competitive field, enrolling in STEM or enrolling in EVerify can help you recruit workers. So with all of that in mind, let's talk about some mistakes we see, because EVerify, like I-9s, it's very easy to kind of go off the beaten path and do stuff that creates liability. So inconsistent use of EVerify. This is number one because so many companies enroll in EVerify. It sounds like a good idea. They're on it. They want to be compliant, and then they never use it. So if you're gonna make the decision to enroll in EVerify, the reason we recommend pre-enrollment planning is because we don't want you to do this. We don't want you to enroll and forget that you did. So when you enroll, make sure you are E-verifying all newly hired employees after enrollment. Unless you're a federal contractor, please do not go back and try to E-verify your existing workforce. That is a huge problem that will cause a lot of issues for you, so don't do that. And make sure you're doing it consistently at all of the sites that you register in EVerify. Companies don't have to register every location, so this is very useful in a multi-state employer context where you may have a site in Arizona where EVerify is mandatory and a site in Illinois where it's not. You can just register your sites in Arizona to maintain compliance, but you want to make sure that if you make the choice to register your site in Arizona and Illinois, that you are also doing your EVerify in Illinois, even though it's not mandatory at the state level. So moving on, another big issue that we see is late verification. I think that the best way to avoid this is just to marry EVerify and I-9 in your mind. They both have similar timeframes. Just like the employer has to complete Section 2 within 3 days, you have to initiate your case in EVerify in 3 days. So make sure you're doing that. You're never going to do EVerify first because you're always taking the data from the I-9 to create your EVerify case. So it's a chicken and egg kind of thing. You're never going to have an EVerify case before the I-9 has been completed. But you do want to make sure to do both within that 3-day time frame. Now, the number one question we get on this is, oh my gosh, what if my employee doesn't have their social security number? And that is not a big deal at all. What you do is you wait until they get their social security number. This comes up with foreign transfers a lot of times. It takes a couple weeks to get the social security number. Once they get their social security number, you'll add it to the I-9 form, and then you'll create the case in EVerify. There's actually a pre-written option explaining why the case is late. It doesn't create any liability, so you don't have to worry about it, but please go back and do the EVerify process in that case if you're enrolled. All right, so next up, we've got ignoring your record-keeping requirements. So like NECA mentioned earlier, you have kind of an all or none choice with your I-9s. You can either keep copies of all documents or keep copies of no documents. When you sign up for EVerify, you get an all or some choice. So you can either continue to keep copies of all documents like you've always done, or if you don't keep copies of documents, you have to keep copies of some documents. And those are the U.S. passport, permanent resident card, and employment authorization documents if they're presented. You can't request them. And they're not required, but if an employee happens to present them, you do have to keep a copy. Likewise, if an employee happens to present a List B document, it has to have a photo. If it doesn't have a photo, you have to give it back to them. Another thing is you have to write the EVerify case number on your I-9. Once you've done it, that's a kind of a tricky one I think that some people miss. And then finally, social security numbers. When you enroll in EVerify, one of the requirements is that your employees have a social security number and give it to you. You have to have it to create the case in EVerify. Doesn't mean they have to give you the social security card. They just have to give you the number. So that's one thing to watch out for. That's different from just doing an I-9. And then finally, let me go back. Issue number 4, TNCs. So 9 times out of 10, when you do an EVerify case, you're going to get a result in about like 2 seconds that says employment verified, and you're going to be really happy because that means the system's working like it should. Every once in a while, you're going to get a different result, such as verification in process or a tentative non-confirmation, which we call TNCs because we're really cool people. And either one of these is just not ideal from a timing standpoint, but it really has no bearing on the actual employment authorization of your employee. It just means that there's some data mismatch somewhere in one of the databases that needs to be resolved. So what you do when you see that you've gotten a TNC is you do nothing, except maybe you need to talk to the employee. There will be something you have to print out and give them to sign from the EVerify system. But other than that, you're not going to fire them. You're not going to suspend them. You're not going to place them on leave. You're not going to delay their training. You're not going to take any adverse action against that employee. The employee has the right to elect to contest the TNC. They'll inform you of that decision, you'll record it in EVerify, and then they have a certain time frame within which to contact the agency and make the data correction. And then eventually that'll filter down to your system, you'll get an employment authorized result, and everything will be great. You may actually get a non-authorized result, what we call a final non-confirmation. If that happens, then you can terminate the employee, and you should terminate the employee, but not before you get that FNC. If the employee opts not to contest, which does happen from time to time, you can terminate them. You'll record their choice in the system, and you'll be instructed to terminate them. But it has to be the employee's election. You can't take these actions on your own. And then the last issue that we see is selective or discriminatory use of EVerify. So unlike kind of inconsistent use of EVerify, selective and discriminatory use is maybe deciding that you don't need to EVerify U.S. citizens because obviously they're authorized to work. You only are going to EVerify permanent residents, right, as a safety measure. Well, you don't get to do that. If you enroll in EVerify, you're obligated to EVerify all of your newly hired employees, period. And then also don't require more or different documents for your employees. You know, if you have compliant I-9 practices, you're not going to mess this up in EVerify because you're using the same I-9 information for your EVerify case. Don't request special documents for EVerify. Don't do that. But as long as you're compliant with your I-9 practices, you're going to be good to go in EVerify. You know, and I think now it's Eric's turn to tell you about what happens if you're not good at doing EVerify.
Okay, well, whether you're good or not, you might get an investigation, and we hope you're good, because if you do get an investigation, if you've been doing a good job and coming to trainings like this and learning and applying what you learn, you might avoid fines. That's what it comes down to. And so I'll talk for a few minutes both about ICE investigations and about Department of Justice investigations. So when ICE comes calling, it usually starts with a notice of inspection. Sometimes they mail it, but they usually show up in person. The ICE officer is pretty charismatic and friendly on the front end, right? They're not as fun on the back end when they're handing out the fine to you, though. On the front end, when they show up, they will offer, if you want, you can waive your 3 days that you have. There's always a little checkbox, and they'll ask you to waive your 3 days if you'd like to do that. We never want to waive our 3 days. We always want to take the 3 days that we're entitled to under law to respond, because there's a lot for us to do during those 3 days. And the first thing we want to do is notify the attorney, because the sooner we know that you've got an investigation, the more we can do to help you. So don't wait until the 3rd day to call us. Call us on the 1st day right away. When you get one of these notices of inspection, they will ask for all of your active I-9s, meaning for every employee you have on your staff, you have to have an I-9. And also your retained I-9s. So remember, the rule is when somebody leaves, you have to keep their I-9 for 1 year after the date that they leave, or 3 years after the date that they had started, whichever one's longer. And so ICE can ask for all of those retained I-9s, but usually they'll only ask for a year's worth. So in other words, anybody that departed in the last year, they want their I-9 too. Because ICE has to conserve their own resources, so they don't ask for as much as they could in that instance. But they ask for a whole bunch of other things too. They'll want a recent payroll run. They'll want your quarterly wage reports. They will want like a corporate org chart that shows all your other entities. That way they know who else to go hit up with an audit. If you've got a written I-9 policy, they'll want to see that. They usually want you to just summarize. Tell me in a paragraph or two, how does your I-9 process work? Who does it? What's their job title? How long have they been with you? More than one person do it? Is it centralized? Is it decentralized? They just want you to sort of explain to them how you do your I-9s. And so in the 3 days that you get to respond to one of these notices, what we want to do during those 3 days is get everything in order, have it nice and organized, tab the file or the response for them so that it's easy to read. That puts them in a better mood. We want to make sure that we've gathered up all our I-9s from various places. But what we don't want to do during those 3 days, we don't want to be in a position where we have to figure out, well, where are the I-9s? Does anybody know? We don't want to be figuring that out during the 3 days. We don't want to be looking at them to see what kind of shape they're in. That's the reason to do the training today and to do all the work now to make sure things are in order, so that during the 3 days we can focus on these other things. We'll also have to make photocopies of everything, because once you hand it over to ICE, there went your proof of what you had. And so you make sure you have a photocopy. If you've got a lot of employees, just making copies of everything takes a good amount of time. So we want to start right away and get the lawyers involved as soon as possible if you get an audit. This next slide I love. It's a little hard to see on here, but it's also on the ICE website. It's just a snapshot of the process that happens when you get an I-9 audit. It starts at the top with the notice of inspection. You can see down towards the bottom, there's substantive violations and technical violations. The substantive violation can't be fixed after the fact, so it either leads to a warning or an actual fine. But a technical violation, they'll notify you what your technical violations, these are like paperwork errors, and they give you 10 days to fix them. If you can get them fixed, then a technical violation goes away. If you can't fix it, then it converts into a substantive violation and generally becomes a fine. This is the reason that we like to keep copies of the documents. If somebody gives you their driver's license and social security card, and you've got a copy of it, and there was a technical error, you can pull out that copy and see what the error was and maybe fix it and get rid of the fine. But if you didn't save a copy of it and that employee is no longer with you, there's no way to fix it, and so you just generate it, you pick up a fine. Speaking of fines, this chart also comes from the ICE website. This is for the offense of knowingly hiring or continuing to employ someone who doesn't have work authorization. It's one of the most serious offenses. There's a similar chart for substantive errors. This is where you didn't know somebody didn't have work authorization, but you just made significant errors in filling out the I-9 form. And so this is generally where most fines come from. Let's talk mostly about that. This chart applies for more recent violations. This fine structure came out in 2017 for violations after 2015. If you have older violations, there's a different fine structure. And then looking at the chart, there's the percentages column. So the way that column works is the first thing ICE will do after they've taken your I-9s and had some officer go through and basically grade them to find all the errors. They'll assign a percentage. The percentage is sort of your error rate. It's the number of missing and erroneous I-9s as a ratio of the number of I-9s that should have been handed over and been perfect. And I can tell you, I think all three of us can tell you, when we do I-9 audits, the error rate is usually over 50%. It's not at all uncommon. And so I'll just give you an example. If you have, say you should have had 2,000 I-9s, but what you had was you had almost 2,000, but some were missing, and then a bunch had errors, say around 50%. That would generate a fine of $1.8 million. On the other end of the spectrum, maybe you think, well, my I-9s are a lot better than that. I'm not going to have 50% error rate. I think I'll only have a 10% error rate. I will tell you, I almost never see that. But if you did, based on, again, 2,000 employees, you would see a fine level of $109,000. So these fines are significant. That's why we do the training, and that's why we do our self-audits, and that's why we hire people to come in and audit for us. Also, if your company is purchasing another company, we want to think about their I-9s, because their I-9s are going to become your I-9s, and these are significant fines. So we want to talk about this before we make the purchase, not after. This should be part of the due diligence. And then finally, on fines, ICE can either aggravate or mitigate your fines by up to 25%, based on these 5 factors. Business size: a bigger company is presumed to have better training and knowledge and be able to do a better job. Good faith, seriousness: if they find any unauthorized aliens, they're going to throw the book at you. You'll get your 5% max there. And then if you have a history of noncompliance, if you've had previous audits that didn't go well, they can aggravate. And so, again, if you had, say, 10% error rate based on 2,000 employees, that was 109,000. They can mitigate or aggravate up or down 25,000. So these fines can really add up. What triggers an I-9 investigation? They're not at random. ICE takes tips from the public, could be from a disgruntled employee or former employee. Could be you have an employee who doesn't have work authorization, and they break up with their girlfriend or boyfriend, and the boyfriend or the girlfriend calls ICE and says, hey, so-and-so is here illegally and they're working for your company. You should go check that out. So that happens. People get arrested or detained by ICE, and then they talk about everyone else that they know that doesn't have work authorization. If you're in certain security-related industries, something with the power grid or the water supply or the airports, anything like that, you might be subject at a higher risk for I-9 audits. Also, agencies share data. So if you get one kind of audit from one agency and it doesn't go so well, ICE might say, well, maybe we should come and take a look at the I-9s. That might not go so well either. This slide is, if you're going to do self-audits, I recommend about every 6 to 12 months, pull your I-9s and look at them. If I say 6 to 12 months, I figure you might do it every 12 months. So that's why I say that. And then about every 2 to 3 years, have a professional come in and do them. These are some tips to think about. The most important one is the person that looks at the I-9s should not be the person that does I-9s every day, because that's not going to give you the answer. You want somebody that doesn't have the same blind spots. Also, make sure you compare the I-9s against a payroll run. So we're not just looking at this stack of I-9s to make sure they're all okay. We're also asking ourselves, am I missing any I-9s? And then finally, the most important thing is, after you've done it, step back and analyze, what did I find? What were the patterns and trends? Am I mostly having Section 1 problems, mostly having Section 2 problems? How can I apply what I learned in this audit to the future so that I don't continue to make similar errors, or so that my team doesn't continue to make similar errors? Department of Justice investigations. So where ICE is looking at, did you do the I-9s and did you do them correctly and save them? The Department of Justice will be looking at whether or not you did your I-9s in a way that was not discriminatory. And that also comes from the Immigration Reform and Control Act under the heading of unfair immigration-related employment practices, which basically just means I-9-related discrimination. The two main branches of discrimination are national origin and citizenship status. So whenever we're thinking about I-9s, our question is always, do you have work authorization? Show me that you have work authorization. It's never, where are you from? What's your immigration status? Are you a U.S. citizen? Do you have a green card? Show me your green card. It's never those questions. It's always about work authorization. And there's a specific type of discrimination that's defined in the statute as document abuse. That's when we ask an employee, NECA talked quite a bit about this, for more or different documents because that person, for whatever reason, looks or sounds foreign to us. We think, well, that might be a problem. I might get a fine there, so I better ask for more. You're just not allowed to do that. You have to ask the same set of questions to everyone based on the list A, B, and C sheet. And then also retaliation goes without saying. If somebody calls the 1-800 line and complains about you, and then you bring them in and do something in response, that's also under the heading of discrimination. A couple of little blurbs here. It's not discriminatory to prefer a U.S. citizen or national over an equally qualified authorized alien, but that's going to be a question of fact for the investigator, and we really want to avoid that, but I just throw that in because it's true. Penalties. So in addition to monetary penalties, the Department of Justice has a whole variety of things that they can do. They can order you to hire or reinstate someone with or without back pay, going up to 2 years. If you ever look at the settlement agreements, they almost always make the employer promise to get back in compliance, and they come back a year later to make sure you're in compliance. They can have an employer track all of its applicants, meaning by name, date of application, the person's contact information, what position they applied for, and then submit reports to the Department of Justice periodically so that they can call people and make sure that they didn't think they were discriminated against. They can post notices at your workplace that are embarrassing, saying this employer discriminated in the I-9 context. So they have a lot of little tricks up their sleeves that we want to be sure and avoid. So what happens during the investigation? It's very similar to an I-9 investigation. You get a notice, they tell you what to provide, you provide a bunch of documents, your I-9s and supporting documents. They typically will come back for a second round after they've absorbed the first round and ask for more. And if you're not compliant with them, they will subpoena to get the documents. The triggers are very similar. Again, if you get an audit from another agency or a complaint from an employee or the public, that can trigger. And this is important, so I'll slow down on this slide for a minute. We want to make sure that we're not generating evidence of discrimination. It is almost never okay in the application process or the interview process to ask if someone is a U.S. citizen or to ask if they have a green card. The only way you can ask that is if there is a basis in law for it. If the job requires U.S. citizenship for some reason, maybe because you have to have security clearance, that might be okay, but it's very risky. And really what you want to do is stick to these two questions. Are you authorized to work in the United States? And will you now or in the future require sponsorship by the company for employment authorization? Notice we're sticking really closely to, are you authorized to work? Those are the key questions. And then for our final slide, to avoid investigations, I'm talking to a whole bunch of HR people I know, so we want to be consistent. We already know that. Everything we do, we want to do it the same from person to person. We want to create a system to facilitate employee complaints. If an employee comes to you to say, hey, I think so-and-so doesn't have work authorization, or I think something happened that was discriminatory, you would much rather them come and talk to you about that than go to the government. And so treat their complaints seriously and have a system. It doesn't mean in the end that they were right, but there should be a process to take their concerns. And then also I-9, the I-9 process should be performed by people who are trained professionals. We want it to be centralized. We want training. We want accountability. The worst offenders are companies where it's highly decentralized and we have managers or shift leads doing I-9s and they don't really have the training behind it. And so with that, we have a bunch of questions that people have submitted, but also if anyone in any of the offices has a question, feel free to ask. Otherwise, we can run through the ones that we have here.
Go ahead. Go up to there to speak.
With the atmosphere in the country, there being a lot of fraud going on, identity theft and so forth, and if you have somebody coming in, applying for work and they seem to be okay, how is an employer to protect themselves from fraud? Because in Arizona, a lot of times, you know, the Social Security number belongs to 4 or 5 different people.
The employer's obligation is to fill out the I-9 form and do it in a good faith manner and then save it. And once the employer has done that, the employer has satisfied its obligation under the rules. So if an employee presents false documents, but they look real, or in any other way presents a false identity, but it seems genuine and reasonably related to that person, and the I-9 form is filled out correctly and EVerify doesn't detect it, then the employer's off the hook. There's no liability for the employer. So the main tool for ICE is the I-9 form. The I-9 form is filled out correctly, then you've discharged your federal duty.
And just to add on to that, especially for Arizona-specific employers where EVerify is mandatory, I mean, there is definitely there are types of fraud that EVerify can't detect. But if you're an EVerify user and you're returning an employment authorized result, this is an instance where that safe harbor would serve to protect you from any claims that you should have known that, you know, whatever documents were false.
And I'll ask one of the questions that was asked of us. I'm assuming this is asking, can we just redo I-9s instead, or do you have to go through the process of correcting them? So let's say you start looking at your I-9s and you just want to throw them all away. I'm going to encourage you not to do that because that's not allowed. You have to have a specific reason for asking employees to come in and bring new documents for their I-9. So, you know, you're going to have to go ahead and go through that process of looking at each I-9. And if the employee did not complete Section 1 correctly, they are the only ones that can correct that Section 1. You cannot go back and correct that for them. Similarly, with Section 2, let's say there are errors that were completed by the employer. If you have the documents or copies of the documents on file for that employment authorization, then, and you were the person who completed that Section 2 initially, you can make those corrections to the form. But outside of that, you can't just wholesale, you know, complete new I-9s for all of your staff, with the exception of mergers and acquisitions. You do have the option, if you are acquiring a company and all of their employees, you can either choose to accept the liability that all of those I-9s may contain, or you can do completely new I-9s for all of those employees. But you can't pick and choose within that employee or that workforce which individuals you want to conduct a new I-9 for and which ones you want to accept their I-9s, unless, again, you're auditing those I-9s and you have a specific reason to do so.
And just to add on to that, if you are correcting your I-9s and just making the corrections on the old form is turning your form into a hot mess, you have the option of writing the correct information in a fresh I-9 form and then stapling that to the old I-9. But to echo what Nick has said, you can't get rid of the original erroneous I-9. You have to have something that traces the original error to the correction.
I think this would be a question for Meredith regarding, I think this is referring to the employer putting the Social Security number in EVerify.
Okay, so if you're an employer enrolled in EVerify and you make a typo, there is a way to cancel that in the system and then do a resubmission. You just withdraw it. I don't know if it's actually withdrawing it, but you basically select that and say need to cancel due to employer input error, and then you create a fresh case. It's not a big deal.
Also related to Social Security card, somebody asked a question, what do you do when the employee has applied for a Social Security number and is taking an inordinate amount of time? So a couple of things. First of all, if they presented, if the document that they presented for their I-9 was a receipt for a Social Security card, then the only way that would be valid is if they already had a Social Security card and now they've applied for a replacement because the first one was lost or stolen or something. And you could use that receipt for, I think, 90 days, if I remember right. I think that So for some period of time, and it says in the M274 manual, the receipt can serve as a placeholder for the actual Social Security card. But after a while, then you can no longer use the receipt. You have to have the actual card. And so when you hit that point, then you have to have the employee come back in, and they either have to show you the Social Security card or give you a different document. It wouldn't have to be a Social Security card, but in some way they have to prove that they have work authorization. That's for the I-9. For the EVerify, if, say, somebody proved that they have work authorization some other way, let's say maybe they gave a U.S. passport, so there's no question, the I-9's done and filled out, but you can't complete the EVerify because you're still waiting on the Social Security number. In that case, you just wait. When they finally get it, then you go back in and put it into EVerify.
And just another thing to point out there, what we're seeing more recently is that foreign nationals, again, they're here on a visa, an employment authorized visa, and they're going to the Social Security office to request their Social Security card and number, but sometimes the officer that they're dealing with doesn't understand how Social Security numbers are issued for employees that are foreign nationals. So there may be some lag there. So, be patient with your employees if they don't have a Social Security number yet. Sometimes they're doing everything they can, and it's just on, the Social Security Administration to understand how to issue that Social Security number. We're actually seeing that quite a bit lately, which is why we do.
So I think we're done. We're actually a couple of minutes over. Thank you, everyone, for attending today. We did receive a lot of questions, and we did our best to work them in where we could. If you have questions that you feel like did not get answered, please feel free to reach out to us. We'd be happy to answer questions by email as well. Thank you.
Thank you.